Hi, everybody. Welcome to Trial Alchemy, where I talk with the very best plaintiff and defense civil trial lawyers from around the country who are members of the American Board of Trial Advocates, ABOTA, and we talk about what works and what doesn't work in civil jury trials. To be considered these days for membership in ABOTA, a lawyer must have tried 9 civil jury trials to conclusion. Now, the rule was different back when my guest and I were admitted. It used to be 20 civil jury trials. And to be admitted into a BOTA, you just can't have enough with the experience alone. You also have to be found to be an excellent trial lawyer who is honest, civil, and professional in your interactions with your opponents in the court. I'm Monty McIntyre. I'm your podcast host. I've been a California civil trial lawyer since 1980 and a member of ABOTA since 1995. I had the honor of being the president of the San Diego ABOTA chapter in 2014. For most of my career, I was a civil trial lawyer who represented plaintiffs and defendants in a broad variety of cases, including tort, employment, business, real property, and insurance bad faith litigation. These days, I help lawyers in several ways. First, I help them settle cases as a mediator, decide cases as an arbitrator, and decide issues as a referee at ADR services, and handle cases in the areas of employment, torts, business, real property, probate, and insurance. I also help lawyers by making it easy for them to always know the new civil case law in their practice areas with my online publication, California Case Summaries, which publishes one-paragraph summaries of every new civil case in California throughout the year. And finally, I help lawyers become better jury trial lawyers with this podcast, where I talk with guests like my guest today, Tom Sharkey, and with my trial mentoring services. Trial Alchemy is brought to you by California Case Summaries, which helps lawyers save time, know more, and win more. And you can get a 1-year free individual attorney subscription. Only the lawyer can read the summaries, which is a $1,999 annual value, by conducting a half-day or full-day mediation with me at ADR Services, a private mediation. And law firms can get a 1-year law firm unlimited subscription, where the firm can send summaries to every lawyer in the firm, a $6,500 annual value, when lawyers from the firm conduct 2 half-day or full-day private mediations with me at ADR Services. So without further ado, today I'm delighted to have as my guest Tom Sharkey. And Tom has a similar but much more distinguished experience in his practice. These days, he actually works mostly as a mediator, arbitrator, referee, but for many, many years, he's been an active civil trial lawyer, handling a wide variety of cases in both the state and federal courts. And he was a senior partner with the law firm of McInnis, Fitzgerald, Rees, Sharkey McIntyre for over 30 years before he joined Higgs, Fletcher Mack in his later years. He's tried hundreds of cases, including personal injury, products liability, professional negligence, including legal, medical, dental, accounting, and real estate, insurance bad faith, insurance coverage, construction, employment, real estate, securities, aviation, and business commercial matters. And Tom has done both plaintiffs and defense work, although probably over the years, more defense in total. Tom's been a member of the American Board of Trial Advocates for a number of years. He's also a member of the American College of Trial Lawyers. And let me tell you about a few of the awards that Tom has received over the years. He was named as a distinguished alumni by the San Diego School of Law in 1978. Tom received the highest honor that any San Diego lawyer can receive by getting the first Daniel T. Broderick III Memorial Award for civility, integrity, and professionalism in 1990. That's the highest honor you can get in this town. He's been in the Best Lawyers in America from 1995 to the present, and Tom was also admitted to the Consumer Attorneys of San Diego Trial Lawyer Hall of Fame in 2010. Now, Tom has such a long and distinguished resume, I can't read all of it to you, but Tom, thank you so much for being a guest today. It's delightful to have you with us.
Thank you, Monty, for having me. It's a pleasure.
Well, I want to start off with this question. You've tried so many cases, probably more than most people ever do, and you've seen a lot of experiences, but why don't you tell us about one of your most satisfying trial victories, whatever that was?
Well, I've tried really a huge amount of cases over the years. And in thinking about the most satisfying case that I've had, I went through a kind of a chronology of cases that I had kept track of, and really came down to one. I've tried a bunch of cases that maybe would qualify as the most satisfying. I've done a lot of aviation related work. I was involved in the Pacific Southwest PSA crash case here in San Diego in 1978, and the Imperial Airlines crash case also in San Diego in 1969, and other cases. I represented the Conquistador franchise in the NBA merger. And I've done quite a bit of criminal work, particularly in my earlier years. But the case that really stands out is a case that I did, I think it was in 1962, early 1962. I was admitted to practice in 1960, so I was really a baby lawyer back then. And I had made it known to the lawyers that I knew that I was willing to try cases. And John Rhodes, who was a fine lawyer at that time, was in the same building that my office was in. And I came to know John very well. Later, he became a federal district court judge, but became very close friends with John. And he referred a case entitled Crane versus Sears Roebuck to me. And he referred it to me to try the case, which was an honor in and of itself, having John having the uh, feeling that I was able to handle a case at that time of such magnitude, and involved a young couple that purchased a small restaurant in Ocean Beach. And in the process of remodeling it and getting it ready for opening, Mrs. Crane was working in a small room that was like a pantry, little storehouse type of a room that also had a hot water heater located in it. And she was in the process of painting it. And she had gone to Sears Roebuck and bought the paint and the primer. And on the day of this particular incident, she was applying the primer to the wall before she started painting. And the fumes from the primer ignited or were ignited by the pilot light in the heater and caused an explosion. And she was burned very severely. Um, and the case, John had filed the case, and at that time, this was just before California adopted the strict liability tort theory for manufacturers and sellers of defective products. And the case was really sounded in um, uh, a contract, breach of contract type of theory. And so we tried the case. I tried it alone, and there were several really outstanding lawyers on the other side representing Sears Roebuck. Um, and I was very fortunate to obtain a plaintiff's verdict. Um, it was about $200,000 at that time, which was a huge, huge amount of money. So it was not only satisfying in terms of the result, but it was transformative for Mrs. Crane and her husband. It provided not only the wherewithal to pay the past medical bills that she had incurred, but also future medical bills that she had to take care of as a result of ongoing care. And it again, personally was satisfying to see that happen and to be a part of making that happen for the clients. And also because I was able to show Mr. Rhodes that his belief in me in trying the case was well put. So, of all the cases that I've tried, and I think back on this, it's the Crane versus Sears Roebuck case that stands out in my mind. As I said before, there were many other cases that I've tried that were satisfying and to one degree or another, but this got me started in the trial practice here in San Diego. It was a good result and it benefited more importantly than all these other aspects that I've just mentioned, the two clients that were involved. So that's the case that comes to mind, Monty.
That's a great example, Tom. And I think one of the wonderful things that you get in compensation that isn't monetary, but it's probably more valuable than that, is that kind of satisfied feeling that you've helped your client. And especially in a case like that, where you made a big difference in their lives and you really helped them probably for years and years and years. So good for you. And that's a great example.
Yes.
Um, Now, you've probably felt the same kind of satisfaction for all your clients, but I think your earlier victories sometimes have that place in your heart where you are very fond of those and making that difference. I know that feeling myself. Now, Tom, you've been a member of ABOTA for many, many years, and I think back in the 60s you became a member. So, why is ABOTA important to you?
Well, it's very important because it's made up of really the finest trial lawyers in the community, not only here in San Diego, it's now a national organization. When it started, uh, I think it was about 1961, 1962 up in Los Angeles, and a group of lawyers who were more senior than I here in San Diego brought it to San Diego. And I was very fortunate to be one of the early members of the organization, and it enabled me to interact with lawyers who served as mentors to me over the years. And I have been a loyal member, I think, since 1964, 1965. And while the organization has changed in terms of its qualifications, it nevertheless seeks lawyers who are interested in becoming good trial lawyers. It provides a lot of facilities to enhance those skills for young lawyers and for older lawyers such as myself. It's a place where we can meet and stay current with the younger generation and lawyers, and also take on the role as mentors ourselves. So it's been a very valuable experience to me, Monty, over the years. And like I say, I am a real believer in ABOTA. I try to attend as many meetings as I possibly can and to serve where I can in the organization.
Thanks, Tom. Let's move to getting prepared for trial because we're going to talk mostly today about trying cases, but you have to get ready. And you've done so many trials over the years, but I want to ask you this. When you get to the point where you know you're going to have to try the case, and it's gonna go, you can't settle it, then how have you developed, what system have you developed over the years to get prepared? And what things do you do in terms of getting ready for trial? And what things do you have others help you get done to get ready for trial?
Well, right from the very beginning, I found that making a chronology of the facts, sitting down with the clients and having them relate the facts to me, or when I was on the defense side, getting the file from the insurance carrier, going through it very carefully and making a chronology of when the incident occurred, what happened thereafter. For example, if it was a automobile case and I was on the defense, I wanted to know, what happened to the plaintiff? Did the plaintiff get to the doctor the same day as the incident occurred? Was there some gap there before he or she did go to the doctor? And then thereafter, a chronology of what the treatment consisted of, who the doctors were. And I just have a complete list from beginning to the end of whatever the story may be. And then as I would take depositions and get various forms of discovery, I would add to that chronology. So I kind of lived with it from the beginning until the time of trial and thoroughly understood what those facts were. The other thing that I would do and found very, very helpful was to uh, get the verdict form that was going to be used at the time that the jury was instructed and sent out to make its deliberations, because that, would give you an overview of the elements that needed to be proved, whether you're on the plaintiff side or whether you're on the defense side. And then the third thing that I found to be very, very helpful was to frame questions that were based on the applicable jury instructions that I knew were going to be uh, given to the jury. And for example, with respect to doctors, if I were taking their depositions, for example, when I was doing plaintiff's work, I would take the jury instructions that I knew the court had to give, and I would frame those in the form of a question, such as, um, Doctor, would you agree that notwithstanding the fact that the X-ray showed that the plaintiff, my client, had a degenerative condition in his neck and his back, that there's no evidence that he had any complaints or any treatment, and wouldn't you agree that more likely than not, this uh, automobile accident was a substantial factor in causing his complaints and the treatment and the ultimate surgery? And there would be a jury instruction that the court would give concerning uh, the pre-existing injury, the eggshell type of plaintiff instruction. And I would ask those questions in the form of or in the depositions, and then I would have answers to those questions at the time of trial in the depositions, where I could have the doctor, when he was on the stand, just hold him tight to those questions. And when his answers were given, I could then refer in final argument, for example, to the specific questions and answers and the jury instructions that the court had to give. So I found that to be very, very helpful. So those things that I just mentioned were kind of the skeleton that I used, or the roadmap that I used, in order to get myself ready. And then I would also use it in terms of working with my various witnesses. If I had a plaintiff, I would work with the plaintiff. If I had, a defendant in the case, I would work with the defendant in connection with all those aspects that I just mentioned. But that was the methodology that I used, Money.
Great. And Tom, you've been on both sides of the cases representing plaintiffs and defendants. Let's talk a little bit about when you go to trial, there are lots of good trial lawyers who come up with trial themes to be able to quickly kind of explain what the case is about. And whether it's on the plaintiff side or the defense side, what are some of the successful trial themes that you've used over the years?
Well, for example, on the defense side, the theme of everyone is responsible for his or her own care, whether you're a plaintiff or a defendant. And if I uh, uh, a defendant that, for example, hits someone in a crosswalk, I mean, I would use the theme that whether you're a driver of an automobile, a person on a bicycle, or a person crossing a street in a crosswalk, you have the obligation of acting reasonably in order to prevent harm to someone else as well as yourself. And that would be a theme on the plaintiff side. I mean, depending upon the nature of the case, I know in that Crane case, the theme that I tried to articulate was that this particular primer that Sears Roebuck sold was not really tested to be fireproof in a situation such as the occurrence that happened to Mrs. Crane. And it was really basically because they were interested in making a profit and as cheaply as possible to manufacture that product. So it was a risk versus benefit type of a thing. So whatever the facts of the case would lend itself to, the theme would kind of develop over time so that it would be available to me at the time then that the trial began, and then I would try to use that from voir dire throughout the various aspects of the case leading to final argument.
Okay, one of the things that's come out in some discussions with other guests on this podcast is, you're trying to come up with a theme, you're trying to be able to connect with the jury, and we'll talk about that further in a minute. But there's also this whole issue of attorney credibility. And so, in your experience, how important is it for the attorney to establish credibility with the jury in the trial?
It's it's a paramount importance. The lawyer is really the like a movie producer, director. Uh, he's also a prime actor, a participant in this uh, show, so to speak, that's being presented to the jury. So credibility is very, very important, and a jury they sit there and they're watching the attorney very carefully, and the way that you show credibility is by simplifying your story, that your case is going to be presented to the jury so that they understand it. You tell them basically what is going to happen by way of testimony, and they're expecting you to produce what you're telling them. They don't want you to fudge. They don't want you to oversell, and they want you to uh, be an honest individual that's telling them the truth. And you just have to be aware of that as a lawyer from the moment you step into the courtroom until the case is over. It's utmost importance.
Boy, I agree with you 100% on that. So now we're getting ready to start the trial. And before we start the trial, let me ask you this overarching question, and that is there are many phases or parts of a trial from the picking of the jury, the voir dire, through the final argument. But when you think about all the aspects of the trial, what do you think is the most important part in a civil jury trial and why?
That's a tough question. I would say this. I think uh, voir dire and opening statement are probably the two most important aspects of the entire trial. The other areas, direct examination, cross-examination, final argument, they're all very important. But the voir dire, I think, stands out, and that's a an aspect of the trial that was probably the most difficult for me. I felt very awkward, to be perfectly honest with you, Manny. In all the cases, as many as I've tried during the voir dire process, it's a situation where here I am, a stranger walking into a courtroom with maybe 30, 40 potential jurors
Right.
and asking them questions that very personal questions. And it's just very difficult for me to do that. And sometimes uh, uh, to uh, allow the potential juror to relax and to give this personal information that they wouldn't normally be giving to a stranger. um, it was very difficult for me. And over time, I think I became adequate at it. I think I did a good workmanlike job after a while. But again, every case, it was always a very difficult process for me. But I did recognize how extremely important it was, because I think that picking the right jurors for the individual case that you're trying is of supreme importance. Uh, People want to do the right thing, but the reality of the situation is that we all have our own baggage. We have our express and implicit biases that many of us are unaware of, that take over very subtly sometimes in the decision-making process. And it's incumbent upon a lawyer to make sure that the 12 people that he or she gets on that jury are the best suited from the entire group to hear that particular case. So it's very important. Like I say, I think my personality is such that I felt and always felt a bit awkward getting started, but I did learn how to do it, and as I said before, I think I was adequate at it.
And as you're talking about picking the jury, another thing that's a little bit even more of a challenge when we're doing the voir dire and picking the jury, it's really not a correct name of it because you don't get to pick your favorites. The way the system works is you're probably going to throw off the favorites of the other side with your peremptories, and they're going to throw off yours. So you're trying to pick the ones who are the most fair and reasonable who are going to be left. So that's
Right.
even more of a challenge.
It is. It is. It really and truly is. And many, many times, people that you feel would be excellent jurors for your side of the case turn out to be just the opposite, and vice versa. Um, it's it's a real experience in understanding the human process. You have to be a psychologist, I think, to fully understand it. And some lawyers are just amazing at it. I mean, it's almost like watching them at a cocktail party. I mean, they can go up to anyone and have a conversation that where they're relaxed, the person they're talking with is relaxed, and they just have a knack for it. I did not have that particular knack. I think I was much better in other areas of the trial process than voir dire. But again, it was very, very important. And I learned early on that I needed to to do the best I could during that aspect of the trial.
Okay, so in your answer, you mentioned voir dire as being very important, and you also mentioned opening statement. So why do you also think opening statement is one of the most important parts of a trial? I know everything is, but you've kind of highlighted those two. So tell us about why opening statements are so important.
Well, whether you're on the plaintiff side or on the defense side, I mean, that's the opportunity, the early opportunity that both sides have to tell the story about their case. And this is where the jury is, for the first time, learning what it's all about. And it's extremely important that you're able to condense the story that is being told, make it understandable. Um, uh, I don't know what the statistics show, but I do know that many people make up their minds very early on, and they make it their minds up on what they hear and the perception that they have of what they're going to be hearing based on what the lawyers tell them. And they then uh, hold the lawyers to do what the lawyers said they were going to do and to present the evidence that the lawyers said that they would present. So it's extremely important. And uh, if you make a poor opening statement, I think you're just behind the eight ball from that point on, trying to catch up. To me, it's an extremely important opportunity that the lawyers on both sides of the case have to get the story out early and then build on that with the witnesses and the evidence that is later presented.
Yeah, it's very important, and it's your opportunity to tell the story the way you want to tell it in the order that you'd like to explain it to the jury. It's probably not going to come in that way with the witness testimony because it's never that seamless. It's going to be more disjointed, but it's real important to tell a simple, compelling, persuasive story in your opening statement. And that's what you're doing, right?
Exactly, exactly.
Yeah. Well, in terms of these days when lawyers are preparing for trial, there are a number of people on both sides actually who can use focus groups, and they may get them from the internet sometimes or from personal individuals who they meet in a room in town somewhere, or they go to the location where the trial is going to be. And I know you've done some informal kind of a focus group over the years by just talking to people. So, how did you try to get that kind of information to help you prepare for your trial? What kinds of things would you ask people about the case as you were getting ready?
Well, I don't think in fact, I know I've never used a mock jury. I've never presented a case in that format.
Yeah.
But focus groups, uh, I when I had my defense office, I had many lawyers and a large staff, and while they were not unbiased people because they knew the kinds of work that I did. They were very helpful, and I would run uh, particular issues by them. Drinking, for example, how that was going to impact this particular case if my client or the person on the other side had been drinking, and various difficult issues. People with criminal backgrounds. Uh, that were involved in civil actions, how if that evidence came in, how that might impact potential jurors' view of the case. So it was kind of informal, very informal. I didn't bring groups of people together in order to do those quote focus group types of presentations, but did it informally through the office. Would present it to different family members over dinner, just to kind of get their input, that type of thing, but nothing in a formal manner such as now is being done, where they have mock trials and they have formal focus groups. We simply didn't do a lot of that back when I was trying cases.
Yeah. But you were doing it informally, and your informal discussions with people is really the same kind of thing that they do with focus groups now. It's just a little less formal. So in terms of when the trial is getting ready to start, one of the things that can happen is judges will also often have motions in limine. And one of the things I've heard by judges over the years is perhaps a complaint that they feel that attorneys may file too many motions in limine, which trial judges often feel are asking them to prejudge the evidence before it comes in. So if you were going to file motions in limine, what are really the ones you should try to file that are going to be important?
Well, and again, I think the points you made, the ones that are going to be important are the ones that I think should be filed, and again would be case specific. But if you know that there's some aspect of this case that a witness or the lawyer on the other side is going to bring up that you're going to have to object to. And hopefully that objection would be sustained. If it's an important issue, bringing it up in limine in order to get that objection resolved before you're in front of a jury and arguing it to the extent that the judge allows the argument in front of the jury. You don't want that to happen. So I was very judicious in terms of filing motions in limine. I think many motions in limine are very difficult for a court to judge in a vacuum. The judge has to hear the evidence and put it in proper context in order to uh, uh, either grant or deny the motion. So I think what you need to do is to, focus on what is important, what can be presented in the best context to the judge in order to enable that judge to make a ruling, and uh, don't overburden the court with many of these motions in limine that are in my judgment, kind of throwaway type of motions. They shouldn't be filed. I mean, and I think many of the judges feel the same way.
Well, we talked earlier about credibility with the jury, but it's also important for the trial lawyer to have credibility with the judge. And
True.
I think that one way as a trial lawyer you can establish credibility with the judge is if you only need one motion to eliminate, you only file one, you don't file 10. And they appreciate that. Hasn't that been your experience?
Exactly, exactly. And I think if you talk to 99% of the judges, they'll tell you the same thing. It's probably 100% of the judges that would tell you the same thing.
Yeah.
Many it gets kind of like the discovery issues. I mean, there motions to compel various forms of discovery. I think judges look at those also in somewhat the same light as motions in limine. They should be important, they should be significant, and you shouldn't be wasting your time, your opponent's time, and particularly the court's time on that type of thing. It should be really, really significant.
Well, let's circle back a little bit for a minute to the voir dire. And you talked how that was difficult for you. And I think it's difficult for everybody, although there are some people, as you mentioned, who just have a knack for it. But when you were picking that jury, let's say it's case specific, but what kinds of people were you looking for as far as the people that you would feel would be comfortable for cases, whether you're a defense or plaintiff's lawyer?
Well, I was always looking for people that I thought were people who had an open mind, people who understood that our process was to bring in parties who had uh, divergent points of view and were willing to be patient, um, accept whatever that evidence was going to be and put it in proper perspective based on their maturity, their life experiences, and then follow the instructions that the judge ultimately gives them with respect to how they are supposed to analyze the evidence and what they shouldn't be doing and what they should be doing as jurors. And again, that's uh, uh, it's a difficult thing to determine. I mean, as I said before, I've voir dired people that I thought would be great and turned out to be very poor witnesses, poor jurors for me, and people that I had no more peremptories and had to kind of take them sort of grudgingly as jurors. It turned out to be very good jurors. A very difficult process. And the other thing that was in my mind is if I liked the individual after talking with him or her and felt that they liked me, and that we could have a cup of coffee or a beer or some such thing under different circumstances. And I felt that that would rub off on my side of the case, my clients to my benefit, client's benefit. Those are the people that I would be leaning towards. And you would hear, don't take lawyers and don't take doctors, don't take teachers, don't take engineers, don't take young people, take older people, don't take retired people. A lot of kind of the lore that we grow up with. And some of it is true. Some of it is true. But it was kind of a gut reaction on my part. If I liked the person, thought that he or she liked me, chances are that I wasn't going to exercise a peremptory on that person.
Yeah. Well, now we've talked, I think, pretty well about the opening statement. Before we get into some other things, in dealing with different cases, all cases have good and bad aspects to them. If it's, especially if it's going to trial, if it only had a lot of strength, it's probably going to settle. But you've had to deal with lots of cases as a defense lawyer and a plaintiff's lawyer where you had bad facts that you had to deal with. How have you dealt with those things in your cases?
Well, again, it's very fact specific, but I found that being upfront with the jury, in voir dire, uh, uh, in opening statement, and meeting it head on. If I was a plaintiff and I, had some problem or my client had some problem, drinking many times was, a factor, or using marijuana or some such thing. You can't hide it, and you know that the other side is going to bring it out, and it's going to seem as if you were, trying to sweep it under the rug and hiding it from a jury. And I found that, bring it up and let's talk about it, right from the beginning. Don't let your opposition bring it up. So that was the approach that I used, and I would tell many times it's very difficult to explain to a client, that well, they only had a couple of drinks. Well, yeah, okay, but the other side's going to bring that up, and I'm going to
Yeah.
find out, from a jury whether, a couple of drinks is going to make or break this case. And well, you don't really have to. Well, no, this is the way I'm going to do it. And I found that that is the way to do it. And I know if I were sitting on a jury, um, good facts, bad facts, bring them up because I'm going to have to deal with them as a juror one way or another eventually. And I would respect the credibility of the side that brings it up. And that's how I felt about it, Mike.
Yeah, and that does go back to the credibility of the lawyer because if you're bringing up stuff bad for you and your side of the case, I think that shows credibility to the jury and that helps you in having them feel, well, yeah, he's being honest with me and he's telling me the bad stuff as well as the good.
Yeah. And I think, again, over the period of time that it takes to try a case. If you start off right from the beginning in voir dire by expressing that attitude that I'm going to be very uh, frank and level with you, ladies and gentlemen of the jury, that atmosphere goes right through to the end, and I think it's uh, very beneficial to the lawyer that does that and the client that he or she represents.
Yeah. Well, let's talk about something somewhat similar, and that is, let's say you were a defense lawyer and you were defending a case where the plaintiff was very likable and they also had significant damages. How do you deal with the sympathetic or likable plaintiff?
Well, on the defense side, it's obviously very difficult because you know that if this individual is hurt and is a sympathetic type of witness, that in terms of damages, I mean, it could be a large compensatory award, and maybe even if the facts are such, a punitive award. Um, I for example, cross-examining a plaintiff like that, if I were on the defense side, would be respectful. I would be sympathetic in terms of the type of approach that I used with the individual, but would be, expressing the concept that there are, again, two sides to every story, and notwithstanding the fact that this is a sympathetic individual, I'm dealing with that person in a very professional level, and hopefully will not have a jury score points against me simply because of the sympathetic, empathetic type of person that the individual is. Again, it's very, very difficult when you're on the defense side and you're dealing with someone like that. When you're a plaintiff and you're presenting a person like that, I think you have to be, careful that you don't overdo it. If the jury feels that what you're doing is trying to take advantage of the situation and uh, just going too far. I mean, there's a line that they can tell. So you have to use good judgment, Monty, whether you're on the either side, and you have to adjust and adapt yourself to whatever that situation might be. And again, kind of putting yourself in the shoes of a juror of a juror. How would I react to this if I did A, B, C, and D versus D, E, and F? And then you make that judgment as you're going along. That's how I did it.
All right, well, that's great. So we're in the trial and you're examining witnesses, and you also are going to do direct exam. We'll talk about cross in a second here, but think direct exam is sometimes underappreciated. Do you think that's an important part of the trial? And, what's important about trying to do that right?
Oh, it is. Uh, as I said before, I think that it's on a par with, voir dire. This is the first time now that the jury is going to be hearing your side of the story, and it is a story. It's a narrative, and you have to do that by making an interesting, compelling, but concise statement about what this case is going to be. And it's going to be, ladies and gentlemen, you're going to hear the following story as to how we come before you here today. We have a disagreement with the other side, and here is what you're going to hear as I present my evidence. And, I do the same thing. And you also, ladies and gentlemen, will hear from the defense at A, B, C, and D, and you will understand when you put the two together that the plaintiff side, if I'm on the plaintiff side, is the side that is telling the story as it actually happened. That's the impression you must be creating by telling whatever your story is, and again, simple, concise, to the point, and that's
And
what's we.
and when you get to the point where you're doing direct examination of your client and other witnesses, how do you continue telling the story with your direct examination?
Well, you need to ask the in your direct examination. You need to ask the questions that's going to allow the witness to tell the story. And you again, here's like being a director or producer in a movie or in a play. I mean, you're in control. You give the opportunity to the witness to tell the story in an appropriate way in accordance with the rules of evidence. And again, it's a judgment as to how you do that, but you have to be aware that this is being presented not for your benefit, it's being presented for the jury's benefit, and you've got to put yourself in that jury box, and how would I be receiving? What would I be interested in learning from this particular witness? And that's the kind of question then, the answer to which you've got to get from them in order to present this story and keep it moving in the direction that it needs to go, so that at the end, you're going to be in a position to tie it all together in a final argument and show that based on what all of this evidence is, that you should be on the winning side.
I like what you say about a trial lawyer is kind of like a movie director, and I've said that over the years. I say the movie directors have it easy because when you're the movie director, you get to tell the story. In a trial, you have two different stories being told by two different directors, and
Yeah.
each one is trying to say that the other story is no good.
Well,
So,
that's the tension, in our system. I mean, that's what it's all about, is to present these two conflicting stories, and you got 12 people, your peers, that are hopefully mature enough, fair enough. They're going to listen to this, and they're going to make the correct decision. And I think more often than not, that's exactly what happens. I think the jury gets it right 99%, well, maybe 90% of the time.
I think you're right. I've had the fortune of serving on two criminal juries in San Diego, and I was very impressed by both groups. I thought they were very conscientious. They really try to do the right thing. I didn't feel that they think the way that lawyers and judges do, but they figured it out in their own common sense way. So I
Yeah.
agree with you. I think they most of the time get it right. So let's talk a little bit about cross exam. And I know lawyers have a lot of fun with that, but when let's say you're going to impeach a witness where you think you'll get a chance to, you think they're going to say something different on the stand. What are some of the ways you have found to be effective for impeaching the witness under cross-examination?
Well, I think to start off with, Monty, uh, I think it's very important when you're attempting to impeach a witness that you're really impeaching the witness on a material fact. So many times, lawyers will attempt to impeach on minor inconsistencies, and I think that has a terrible effect with a jury. It's almost like nitpicking after a while.
Yeah,
So you have to pick a true inconsistency, and you can't be fumbling around when you're doing it. I mean, if the answer should be yes to this dynamite question and it comes out no, you can't spend 5 minutes fumbling through your papers trying to get the deposition excerpt or the document that's going to impeach them. Or if you're using an Elmo, and today I know they've got all sorts of technology. You've got to get it. You've got to ask the question, get the answer, and if you're going to impeach right now.
yeah.
Uh, and I used to see when I was trying cases that, lawyers would fumble around and pretty soon the jury would become impatient. They'd forget what the question was, they'd forget what the answer was. And finally, when the lawyer would find out what it was, and the answer was blah, blah, blah. The jury's sitting there thinking, what's that about? So it has to be done right now, and then you move to the next question. The other thing that I found is many times lawyers will get an answer to an interrogatory that they feel is somehow impeaching whatever the witness is saying on the stand, and by the time they get through, isn't it true that we sent you this question and then the answer came back and the jury's trying to understand, what's the question, what's the answer, and then the witness is up there saying, well, my lawyer and we sat down and it just gets lost. It just gets lost. There are times when there are answers to interrogatories that are dynamite in terms of impeachment, but there's so many that you have to be very careful. You have to be very careful. So I guess what I'm saying is that if you're going to impeach on a material point, and be ready to present that quickly to a jury so that they get the full impact of it.
So you would be ready, and preparation is key to be a good trial lawyer. Let's say you knew the deposition of this witness, you knew where the page and line was. So when they gave you a different answer in your cross, would you read the depo or would you ask the witness to read the depo?
Most of the time I would do it. And what I do on a yellow sheet like this, I used to go through each deposition, and I would know that here's the area here that that's going to be if there is going to be impeachment, it's going to be in this area, and I would have the question, and I'd have the answer, and I'd have the page and the line number, so
Yep.
that if it happened, I was right on it. And today, I mean, you can have with this technology excerpts from depositions and excerpts from documents, so that if they're going to use it for impeachment, you can have that flash up on the screen immediately. But it's preparation that takes a long time to do that. You've got to go through,
Yep.
each deposition, each document, but it's well worth it. It's well worth it.
Yeah, in my trial experience, I came to really like the deposition video clip with the question and the answer and with the transcript below that the jury could read at the same time because you ask the question, they give the different answer, you have the clip, you show it, they see the difference, it's immediate and it's very powerful. But reading a depo can be just as powerful, but I think visually seeing it and have them see the transcript of what they said and hearing it really makes an impact with the jury.
I agree. I agree. And sometimes if you've got a witness up there that you're impeaching over and over again, that sequence that you have just described becomes very effective. I mean, a jury pretty soon gets the impression. I mean, here's the question, and they're thinking immediately, there's going to be something that's going to flash up on the screen, and then they
That's
see it,
right.
and it has a tremendous impact. Tremendous impact.
Well, and if you do that with the witness in the cross, which you should, then after you nail them with like three or four things where you've got it all lined out, I've seen lawyers, and I've done it too, and I'm sure you've done it, where you've got the depo up there and you ask them another question, they just say something that they think is going to be truthful because they don't want to get impeached again.
Yeah. After a while, I mean, if you're fortunate enough to be able to do that with a particular witness, I mean, you could, you're the minute you pull up your yellow pad, I mean, you could say fresh fish and they'd agree with you. I mean, they know what's going to happen. I mean, you got a meeting out of your hand. Uh, that doesn't happen often, but I've seen it. Other lawyers do it, and I've done it myself, and it
Yeah,
can be very, very effective. And you get the pseudo expert up there that knows it all. And if you impeach him three or four times, from that point on, I mean, you've got a meeting out of your hand. Um, uh,
yeah,
so it's an art form, I think. It's not only a science, it's an art form, but preparation, Monty, is the key. You've got to have the wherewithal to do that, and
yeah.
the way you get that is by spending hours going through depositions and documents and so forth. But it is worth it and can be the difference between winning or losing a particular case.
Yeah, it could be very, very important. So, in terms of the cross examination that you do, have you most often done what I would call the traditional closed cross, where you're asking focus questions, mostly controlling the witness, yes or no answer, or do you use other forms of cross examination as well?
I think I've done both. I think that starting out with a witness, I think you have to control them. I think
Yeah,
you're asking questions. Uh, isn't it true, Doctor A, B, C, and D? And would you agree, A, B, C, D, and E? Um, and once you do that, there may be areas where you can kind of open it up a bit and ask more narrative type questions. Many times there are areas that doesn't make any difference what their answer is going to be. It's not going to hurt you, and in asking the question, you may be moving your story, so to speak, further along, and the jury is hearing it in the question. But you have to make a judgment there. You have to be very, very careful. But the way that I would do it is I would start off controlling the witness, and then depending upon how that was going, and if there were areas here where I felt confident that I wasn't going to get hurt, no matter what the answer was, I'd ask more open type questions. But again, it's a judgment call.
Yeah, yeah. Well, in terms of final argument, let's go there for a little bit. So when you're giving your final argument, what's your strategy? What are you trying to do, and how are you trying to help the jury so they can go through and do what they need to do and do it properly?
Well, I think summarizing the important parts of the case, important evidence, whether it's documentary or whether it's witness testimony, I think that's very, very important. I think um, going through the verdict form is very, very important. I would always um on the Elmo have it blown up and go through each of the questions that the jury needed to answer and would tell them why they should be answering it in favor of my client. Um, the damage area of a final argument is very important. And again, if you're on the plaintiff side, you do it one way as opposed to when you're on the defense side. The plaintiff is, proving the non-economic damages such as medical bills and that type of thing, and then talking about the non-economic damages, pain and suffering, and there are different ways of doing that. You could use a per diem type of argument for non-economic damages. There are other ways that you can do it by comparing prices of, you know, objects that we buy in order to make our life more comfortable, that type of thing, and then use the analogy to compensate an individual who's now deprived of the ability to enjoy that type of thing. On the defense side, it's it's a little bit different. I would even in cases that I felt that I was going to get a defense verdict, I would always talk about damages on the defense side. And the way that I would lead up to it is by saying something like, after I'd argue the liability aspects, I'd say, ladies and gentlemen of the jury, the judge is going to instruct you in a few moments here on the damage issue because it's been raised by the plaintiff, and the judge has to give you all of the instructions, not knowing what your decision is going to be. Some of these may be irrelevant, and I believe damages would be irrelevant, but the judge has to give you those instructions. And so in that same vein, I'm going to, while I believe that damages are not, the plaintiff is not entitled to damages in this case, in that same vein as the judge giving you those instructions, I'm going to comment on those myself and then start talking about damages. I would always give them a range. I can't think of any case that I've ever tried where I just, said zero, put zero on, and not give them some range, because if you're wrong, I mean, you could really really have a terrible result. So I would always give some type of a range, but that's how I would lead up to it. And then what I would try to do is to, point out that if there is going to be a verdict, the medical bills here is something that need to then to be paid. And in terms of future medical, you heard some testimony here about some type of treatment that the plaintiff may need in the future. Go ahead and add that to it. And in terms of compensatory damages, I would then make some sort of or give them a range and indicate that on top of the medical bills, past medical bills, future medical bills, past lost earnings, future lost earnings, X dollars here would added to those numbers make or give this plaintiff a good quality of life based on the injury or whatever it is that they're suffering, some kind of an argument like that. And I would tie many times I would tie it to their employment. For example, if they were making $30,000 or $40,000 a year, I would indicate in terms of compensatory damages, 4 or 5 years of times their $40,000 annual earnings would be an adequate sum. And point out, particularly in opposition to a per diem type argument where they're talking about, $100 an hour for 24 hours a day for 7 days a week for 20 years in the future. I would say that's unrealistic. Use your common sense, ladies and gentlemen. You don't buy a television set and pay. I'm willing to pay $100 an hour in order to enjoy that television set. There is a reasonable price. That we all use common sense to evaluate that at. And there are different analogies like that. You don't buy a car thinking that I'm going to pay the dealer, $40 a mile that I intend to drive and multiply that out for over 10 years. That's unrealistic. It's not using common sense. And the argument is only being made here for purposes of this trial. That's not the way people in the real world, using common sense, being honest, being realistic, evaluate anything. Words to that effect, Bonnie. I'm not saying it as articulately as I should be here, but that's the type of thrust of the argument that I would make.
No, those are great examples, and I think that that's a difficult thing for juries to come up with is how do you put dollars on non-economic damages? So you're giving them helpful information that they can use in trying to come up with their
Yeah.
decision. Well, that's
Wrongful
great.
death is a great example. I tried a zillion wrongful death cases, and people who lose a loved one. I mean, what a terrible, terrible thing. But the law says that you can't compensate for grief and sorrow. We're all going to die, unfortunately. But what you can do is compensate for the loss that these folks have. And then you try to get that concept over and then try to be realistic. On the other hand, if you're a plaintiff, I mean, what you're saying is, my God, there's no amount of money that would ever compensate me for the loss of my son or my husband or my wife. And some jurors, yeah, okay. So
Yeah.
you depending on which side of the coin you are, you have to adjust your argument, and that's why we are trial lawyers. And we have good plaintiff trial lawyers, we've got good defense trial lawyers, and that's what makes our system work, and that's why it's so beautiful. That's why I've enjoyed it all these years.
Yeah, that is so true. Well, Tom, it's the time goes by so fast. I've really been thoroughly enjoying this conversation. I thank you so much for bringing your wisdom and experience. I want to ask you one last question to close it out, and that is this. What is the best advice that you can give to somebody who's less experienced? Maybe they've tried a case, maybe they've tried no cases, but they want to become a trial lawyer. What advice would you give them based upon your career and your experience and things you've learned along the way?
Well, uh, don't be afraid to get down there and try cases. That's the only way you're ever going to become a trial lawyer. Um, Before you go down to try a case, sit in on cases and see how lawyers present evidence and make arguments on both sides. Attend seminars. If you're uh, ABOTA puts on seminars, and even though you may not be an ABOTA members yet, many times there are seminars that you can attend. They're very worthwhile, very worthwhile. There are books that are being printed today that weren't printed when I was coming up as a young trial lawyer that are very good. I mean, it gives you an insight of what to expect when you're trying a case. The other thing is I would uh, develop a style. It takes a while. Um, you look at lawyers and steal the good parts that you see that they have in their presentations. We all take from people that we see and we adapt those styles to our own personalities. Be yourself. Uh, don't try to be somebody you're not. If you're a good voir dire person, you got away with people fine. But if you don't, if you're like Tom Sharkey and you feel awkward, just work at it, and you can become adequate. And you may have uh, 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 abilities in other aspects of the trial, direct examination, cross-examination, final argument, and put it all together. It takes time. You've got to go down and do it. You've got to be willing to lose a case. I've lost cases, as everyone has. And the old saying is, if you don't lose, if you haven't lost a case, you haven't tried any cases. I mean, it's going to happen. It's going to happen. Be civil. Uh, don't consider the attorney on the other side your enemy. He's not your enemy. He's your adversary. It's like in a football game. I mean, you shake hands, at the end of the football game, and you do the same with trials. Um, and it's just using common sense, I think, Monty. It's like anything, and preparation is the key. There's no question. It's true in all walks of life, all business, and particularly in trial work. It's a lot of long hours, but if you're cut out to be a trial lawyer, it's all worth it.
Well, Tom, that's great advice. And thanks so much for sharing all that you've learned over the years today. It's been delightful. Thanks so much for being a guest today on Trial Alchemy.
Thanks for having me. I enjoyed it.
All right, everybody. Well, that's it for today's session. And until we meet again with the next podcast episode, do well and be well.